Reference letters nowadays tend to be very simple and limited to confirming job titles and last dates of employment. Many employees, especially but not exclusively more junior employees, consider such references to be inadequate and want their employer to write something more positive that describes their achievements and contributions. Employers should exercise extreme caution if they're asked to provide more detailed reference letters to former employees, and should be aware of the possible legal implications that arise from providing such reference letters. Employers owe a duty of care to potential future employers. If an employer gives a positive and glowing reference, then it is likely that the potential employer will rely on it when making hiring decisions. A potential employer that relies on a glowing reference may be able to sue a former employer, or, in the case of a personal reference, the writer of that reference, for damages if the information contained in the reference is inaccurate or misleading. For example, if a former employer provides a reference saying that a former employee has particular knowledge or skill, it may encourage a potential employer to hire that individual. If it turns out that the employee does not have such knowledge and skills, then the new employer would have suffered a detriment by hiring the individual, and it would have recourse for the resulting loss against the company or the individual that provided the reference. Former employees may have legal recourse against an employer that provides inaccurate references. The United Kingdom's House of Lords in 1995 held in Spring v Guardian Assurance that a former employer owes a duty of care to provide accurate information when writing an employee's reference. In that case, the House of Lords held that an inaccurate, bad reference could be a breach of duty in tort for negligence. In such a case, the potential employee would not have to prove actual loss of employment, but only that they lost the reasonable chance of employment due to the inaccurate reference. References are often provided by a former employer directly to a potential new employer. Neither party should, however, assume that the reference is confidential and won't be seen by the employee. The Personal Data Privacy Ordinance allows anyone to request and obtain copies of data for which they are the data subject. In other words, that directly concerns them. This would certainly include a written reference. Employers should develop and circulate a policy for dealing with references. This should include identifying who within the organisation can issue a reference, the type of reference that may be provided, and whether or not personal references are allowed. Often the key purpose of a reference is to confirm the accuracy of statements made in a candidate's CV or job application. This can be achieved by simply confirming the employee's job title and dates of employment. While the majority of references are limited to such simple factual information, it would still be advisable for the reference letter to state that it is the employer's reference policy to limit the content of references to such factual information only. This avoids the argument that a failure to say more may create negative connotations. If an employer or individual wants to provide a more detailed personal reference, including opinions about an employee's skill and performance, the writer must ensure that everything written in the reference is true and verifiable. If personal references are permitted, the employer may want to limit their use to only being permitted to support an employee's application for certain professional qualifications or admission to certain professional bodies, rather than to support alternative employment. In any event, any policy that does allow for personal references should strictly require the writer to mark them as expressing their own personal opinion and not the opinion of the employer. Hong Kong is a small place, and within certain industries, it's often expected that everyone knows everyone. It's not uncommon for a hiring manager to reach out to potential candidates' former managers informally to find out the truth about a potential hire. Such practices should not, however, be encouraged. During such a telephone call, it's more likely that instead of information being exchanged, there'll be one person's personal opinion about the employee. Opinions are very difficult to justify objectively. As mentioned earlier, if someone relies on that opinion either positively or negatively to hire or decline a candidate, there may be legal consequences. On the topic of telephone references, where the parties know each other well, more often than not the references will be via WhatsApp or similar chat. Such conversations are very informal and are notorious for misinterpretation, especially when emojis are used. Neither party to a telephone call or a chat of this kind should assume that it is off the record or won't come to the attention of the employee. Even if the communication is entirely verbal, often one or both parties will make some form of note that it has taken place. Not necessarily with a full attendance note or memo, which actually might be more helpful if things went wrong, but more usually with a quick email or WhatsApp to HR or the hiring manager giving a thumbs up or thumbs down to the candidate.